You're listening to the Today's Conveyancer podcast, the leading source of information for residential property lawyers in England and Wales. Don't forget to subscribe and sign up to our free newsletter at todaysconveyancer.co.uk. You can also follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Conveyancer podcast. Today I'm talking about complaints. Of a sort. I'm talking about complaint handling, how we can best deal with them. I'm also talking about compliance in general with Kate Burt. Kate is the founder and owner of Hive Risk and joins me for the podcast today. Thanks very much indeed for joining, Kate.
Good to be here, David.
First question is usually the same. I ask you, who are you and what do you do? So I'd like you to tell me a bit about yourself and about Hive Risk in just a second. And as I said, today the discussion really is about what compliance services are, how they best work, and then we're going to talk a little bit about some of the support work you do around complaints handling for law firms. We were chatting about a column that Today's Conveyancer publishes, which is shared with us by the Ombudsman. And usually has some really interesting insight into the way that the Ombudsman deals with complaints and how they approach complaints. So it's well worth a read. But in the first instance, Kate, tell us a little bit about yourself and what you do.
Thank you. So I usually start by saying I'm a solicitor. Although I'm in my consultancy now, I am still a practicing solicitor and still do consider myself to be at the core a solicitor. So in terms of my background, I was a litigator for many years, doing insurance litigation, personal injury work. And I did that for around 15 years across 3 top 50 law firms. In your very much your traditional fee earning role as in litigation. So the time recording, the clocking in and clocking out, and your sort of traditional route heading towards partnership in that kind of traditional role. Around 2016, I sort of had this entrepreneurial bug that wouldn't leave me, and I had to sort of scratch that itch, if you like, and took the bold decision. And I think some who were watching on and sort of family and friends and colleagues at the time were thinking sort of a crazy decision to sort of just hand in my notice to pursue something different. And I did, at that point, I didn't quite know what that was, but I knew it wasn't what I was doing. So I'd look around in that sort of traditional setting, and it didn't light me up to sort of follow that route through to partnership. I handed in my notice in 2016, and the sort of the path became clear as I was leaving that sort of traditional route, that actually somehow I fell into the world of compliance by sort of a strange series of events, really. I was introduced to someone who owned a claims management company, and they wanted to be a law firm. So they asked for my support in getting them over the line with their ABS application. And I was quite open with that, say, OK, I'm a solicitor, I can help you, but as long as you realise it will be the blind leading the blind at this point. They took the leap of faith. They needed the support, and I was happy to sort of throw my hand in. And it was through doing that piece of work that actually I realised compliance is a specialism in its own right, which I didn't fully appreciate for 15 years as a solicitor. Fast forward to now, I now run Hive Risk, which is a boutique compliance company which services law firms of all different shapes and sizes across the country, just purely on their risk management and compliance. And we've really seen a massive growth in the last sort of 12 months in this space.
We were chatting before we started to record today that firms still don't place enough emphasis on compliance. We know that it's one of the biggest issues that PI insurers see. We know it's still a huge source of frustration for law firms, but we still see culps and coffers in fee earning roles.
Yes, and it really depends on so we see all sorts of different shapes and sizes of firms, and sort of the lower end and smaller firms, we're still seeing those fee earning culps who are wearing all the hats. In fact, they'll be wearing the hat of culp, MLRO, data protection officer, COFA, all the hats, as well as responsible for fee earning as well, which, you know, it doesn't take a specialist to say something's going to give in that scenario. Either the fee earning work's not going to be getting the attention it deserves, or there's going to be gaps or lacking on compliance. And we see time and time again that sort of profile of individual is really drowning and not getting to the compliance. They know it needs to be in a better place, but how do they get from where they are now to that better place when actually they've got no time to do it? And then comparing that to your bigger firms where the culp isn't fee earning and they've probably got a full compliance team around them, there's no such thing as compliance done. And there's always priorities that take precedence over some of the more project work that needs to be done on compliance. So if you ask any law firm, no matter whether you the sole practitioner right up to you know top 200, compliance is not done. It's never done. So it's really looking at where are our areas of priority and what's our budget to tackle the problem. And that's where I think engaging with someone that's external can help you see the wood from the trees. I had a scenario recently where a new firm wanted our support. That scenario where there's that individual with lots of different hats, and they were really at their wits' end talking to me around they need to get their CQS right. Very quickly, when speaking to this individual, it became apparent to me that yes, there's work to be done on CQS, but actually there was a massively urgent need to sort their anti-money laundering out. This is what I said in the conversation, was absolutely we can help you on CQS, but I concede, although you've said that you're okay on anti-money laundering, just a few questions that we've explored here, it's apparent to me from my experience that's where we need to focus on and very quickly. So it's having that sort of external objective eye on it that actually can see issues that you might not know are there.
And that must be a scenario you come across regularly. You're an expert because you run Hive Risk and you know this is your profession, but the lawyer who has trained as, I don't know, a litigator or a conveyancer or a private client practitioner suddenly thrust into a compliance role, that's a massive challenge for any individual.
Hugely, because compliance it's very far reaching in terms of what it even is. What is compliance? It encompasses so much. When in fact, this is a true story, when I started out in compliance, I honestly thought compliance was the SRA's handbook. So yeah, sure, I can build a business doing that. Read the SRA handbook, and there we are. But very quickly, it was a baptism of fire, understanding actually compliance isn't just the code of conduct issues such as data protection, anti-money laundering, professional indemnity insurance, cyber issues, conflicts of interest. The list goes on what compliance is. And yes, those sort of specialist solicitors who aren't skilled in compliance are going to be out of their depth. But similarly, when we speak to compliance managers and people whose day-to-day work is compliance, they don't have the breadth of knowledge and depth of knowledge that perhaps they need as well. And that I'm talking there at all levels of firms. So even in the sort of the more established firms, we're finding that there are gaps in knowledge.
So at the risk of putting you on the spot, AML clearly a massive issue for firms. And in fact, we're talking in the few days after the SRA have issued their warning notice after their thematic review, which identified that there's still a huge amount of non-compliance, particularly around anti-money laundering. But what other kinds of issues do you see that land on your desk?
It is different every day, and there's all sorts of wild and wonderful things that land on the desk. So taking one particular example, recently we were asked by a firm to look at complaints handling and to do some outsourced complaints. When we actually started work on that, there was sort of a whole lot of issues coming out of that in terms of conduct issues, in terms of negligence issues, notification to insurers, and the wider issues that come from that. So you start looking at something that looks quite simple, like this is a complaint, then actually all these other things fly out. That's fairly typical for something like that to happen. Data breaches is very common in terms of the most common data breaches are emails going to the wrong place, files going missing in the post, and what we're very skilled at there is having that first response to that breach. For a number of our firms, that we are their internal compliance team, so they refer it up to us. There's been a data breach. What we're skilled at is one, advising on how to mitigate that breach, so how to minimize the breach, so whether it's an email that's gone to the wrong place, trying to recall that, or trying to make sure that the individual who's received it's deleted it, so containing that breach to begin with. But then where the expertise really comes in is then risk assessing, right? Okay, what does this mean? What data's been breached, or what's the nature of the breach, and what are the risks around that, and doing a risk assessment to say, okay, is this reportable to the ICO? Is this reportable to data subjects? And having that audit trail and that assessment as what do we need to do next. What we're really skilled at doing is coming to that, formulating a decision very, very quickly on what needs to happen next. Whereas if you don't have that sort of decisive approach, you could be for days mulling over the issue or researching the issue on what do we report, do we not report, and so having that clarity there is something that we're pulled into fairly frequently, those sorts of scenarios that come up on a daily basis.
So let's delve into complaints very specifically, because I must admit I'd not really kind of thought about complaints as a compliance service, but clearly, as you say, it's about that proactivity. It's about having a plan. I mean, how many times do we hear about cyber issues and cyber risk and knowing what to do when the proverbial hits the fan? We're talking on the Today's Conveyancer podcast. Conveyancing still elicits the highest number of complaints into the Ombudsman in particular. Tell me about what kind of complaints you kind of deal with, and not just conveyancing, Kate. You know, what sort of across the board, what do you deal with from a complaints point of view?
Sure. I'll just back up slightly just to say how we work with firms in relation to the complaints side of it, because we work in different ways. So for some firms, we are their sort of fully outsourced complaints handling team. So we'll do everything from acknowledging the complaint, investigating the complaint, speaking with the complainant where appropriate, formulating that response. Other firms, they do that in-house and we oversee the process. But for many, and we've done this for a number of years, we are that complaints handling team. So we sort of on the front line there, seeing what comes through. And as you've said, it is the conveyancing teams that do generate the most of the complaints. And so the reason really behind that, there's a number of reasons. Firstly, it's quite a stressful time for the client, so emotions are high. You've also got often high volume, high number of transactions that the teams are dealing with. And what happens with that transactional approach is sometimes the soft skills are lacking. And what we see sometimes is that the conveyancers perhaps lose the soft human touch when risk corresponding with the client. So the experience the client has is very transactional and sometimes can come off a bit cold and abrupt. And that's where some of the complaints are coming from, is more of that service level feeling as though they are being looked after properly. And we see that a lot. Also with conveyancing is delays. And that often isn't that there has actually been a delay, it's the perceived delay, often due to managing expectations at the outset, that the client feels like it should be dealt with faster, when actually it's still within the normal range that the firm would deal with it, but the experience that the client has is that it's behind. Whereas actually if the expectations are managed better on the front end, then you'll find that the client is much more forgiving. And sometimes a client is going to complain no matter what. You can have the best service. One of the major areas generating complaints, or the reason the complaints come through, is often around fees. And it's the reluctance to pay the fee that then they find other problems with the service as well. So again, it's about managing expectations around how much are they going to be charged, so it's not a big surprise when the bill lands. Abortive fees, for example, are a huge area that the clients signed up to terms and conditions saying that if the matter aborts, then you'll have to pay the fee, but not really paid much attention to it. But then when the matter does abort and they get the fee, they don't want to pay it because they don't feel that they've got any value from it.
And what's your advice to firms about dealing with that as best they can? I mean, you talked about being transparent and setting expectations. Is there more to it than that?
I think there is more to it than that, and I think it's always a good idea to spot trends in what sorts of issues are coming through and looking at some root cause analysis. And it might be a process issue that needs to be fixed. So always looking at not necessarily dealing with the surface issue or which fee earner's name keeps cropping up, they're the problem. Actually, how is that team set up for that individual to work? Are they too stretched? Is that why they can't get back to the clients quickly? Or what's the deeper problem? Because it might be actually you need to restructure the team. It may even be that there's another individual that handles client queries, allowing the conveyancer to deal with the technical issues, but you've got someone there to answer the phone in a nice, calm way and talk the client through it. It might be that, but certainly looking at the soft skills, like some of the complaints that we see are so avoidable, and it's just the tone that's been the delivery of the communication with the client has got their back up. So I think looking at it holistically about the service that you're offering and the client experience, getting back to focusing on that.
Dare I ask what your experience of firms' complaints handling procedures is? Good, bad, indifferent?
Most of the firms we see, they've got a pretty good procedure in place, and you do see occasionally in the headlines. I think there was one last year sometime about a solicitor who'd put their head in the sand and they hadn't dealt with complaints, and then the ombudsman had got involved and they weren't cooperating with the ombudsman, and they weren't following their own procedure at all. I think that's rare. Most of the firms that we see, they do have a good complaints procedure in position. There are the usual errors in there. I mean, you still do see occasionally, I know we spoke before we got on, like the old address for the ombudsman in there. Most firms have got that right now. A lot of firms have cottoned on to the change in the time limit that came in April, 3 years down to the 1 year in the time limits. And the complaints procedures we're seeing, many firms have picked up on that. We still see firms aren't putting in about the SRA, the route to complain to the SRA if there's a conduct issue, and that was brought in with the transparency rules. So that's something that the tweaks that are needed with complaints procedures rather than anything else. In terms of actually the process on the ground, what we do see is when we're taking over is that perhaps the responses that have gone out previous are sometimes too emotionally involved. And what we do there is really take the emotion out of the complaints response. And very quickly, what we try and do is tackle the issues factually and in a way that doesn't get the complainants back up, because that's a skill in itself to sort of deal with it without doing that, but also very quickly trying to bring it to a resolution. And the resolution might be there is no resolution in that, but very quickly getting to that point to say, OK, we've assessed it. This is our assessment and this is our proposal, or we have no proposals. But very quickly getting to that point and then signposting the client to or the complainant to the ombudsman to move off the law firm's desk onto the ombudsman, if it's going to eventually go that way anyway. Because what we see is that so much resource is put into complaints handling from firms, and it sort of meanders on and on and on with no endpoint, when actually a very skilled complaints handler will bring everything to a head very quickly. So set out our position very clearly, and then over to the client for areas of clarification, but then quickly signpost to the ombudsman if there's no resolution there. And I think that's a really empowering thing to do for the firm, actually, to know that you're not constantly going to be in this back and forth. There is an end point, and that's really helps on the resourcing side of it. It's a real management drain.
You talked about the emotional side of complaints, and it's a human emotion to want to fix something, isn't it? Who deals, or who is best dealing with the complaint?
Definitely not the person that's being complained about.
Because that's a natural reaction for somebody, isn't it? They're going to want to try and put it right, or they may feel as though it's an unjust complaint.
Okay, so and this is something that we encourage, is that first line complaints, when it's just a grumble, yes, that individual, what can they do to fix it in that moment? And it might be a really, really simple thing to resolve the complaint before it's got to a formal complaint response, and that very much can sit with the fee earning team. Once it escalates beyond that, or it's apparent that there is a real complaint there that needs to trigger the internal complaints procedure, I think at that point it needs to be objective. Some firms do have their department heads investigate, although I have seen pushback on that from clients who say that's not sufficiently independent. In some ways, that's really, really good, in the sense that department head will see the issues that are coming out and know that department well to be able to then fix the root causes. Some firms use a centralized compliance team to investigate. I think that works really well in terms of the independence and taking the emotion out of it. And it can be quite liberating for that fee earning team to have that strong demarcation, to say, actually, now that's with the compliance team or the complaints handling team, or whatever that team's called, to say, we can still talk to you about the transaction, but that's now been escalated to a compliance team. So it actually keeps it really clean.
And what's your experience of working with the people that are actually dealing with complaints? And nobody enjoys getting a complaint by any stretch of the imagination. But there are times, as you say, where a complaint actually is an identification of a more endemic issue of some description. I mean, are firms open to that? We're still trying to get review platforms off the ground in the legal sector. It still seems to be quite a difficult process to get feedback and work on it proactively for a law firm, which is often what a complaint can be.
And I think that comes down to the culture of the firm and how complaints are responded to when they are reported up, rather than it being a terrible thing that this complaints happen and then there be repercussions for who the complaint is about. It's almost when it's received, the feedback to the individual is very much thank you for reporting this, and almost seeing that as an opportunity to learn from the issue. But sometimes it's a case of backing up that individual and saying, do you know what, that is the client's being unreasonable here, and we've got your back here. And that I've seen gratitude from the individual, that when it's seen that actually the firm has their back on that and will push back, because the client isn't always right, and it's how it's dealt with. Also, in relation to complaints training, is instilling that into the staff, that complaints are inevitable. It's obviously horrible, particularly when you take a lot of care and pride in what you do. A personal complaint is devastating for any of us. It's sort of letting people know it is inevitable at some point, and trying not to take it personally, and that actually we'll deal with it as a firm and learn from it. Any areas that are upheld, let's learn from that and look at the process rather than the person, and getting away from that blame culture.
I mean, I absolutely see that, the customer isn't always right. And yeah, if you can back somebody up, that's massively important. The elephant in the room here feels like reporting complaints to your insurer.
Yes.
And when do we do that?
Yes.
What's the insurer's reaction? And ultimately, is it going to mean that we're going to pay more on our premium next year?
Firstly, to acknowledge that not all complaints are reportable. Service level issues insurers generally aren't interested in. So if something's cost a client a bit more, they're grumbling about that, or if it's delayed, generally insurers aren't interested in that, and you wouldn't be reporting up every grumble a client has to insurers. At the point that it becomes reportable is when actually there's more to it than a service level issue. So there's a potential negligence claim, or there's a potential regulatory issue that's reportable to the SRA or the CLC for CLC regulated firms. And as part of what we do when we look at complaints handling, in fact, I just had a chat with my team this morning about this, is when you're looking at a complaint, yes, you've got to look at the service level issues, but always have in your mind, is this reportable to insurers? Is there a conduct issue here that the regulator is going to be interested in? And what are the learning points? It's also a skill in itself to spot that, because often it can be really hidden that there is a conduct issue or there is a reportable issue if the client hasn't seen that. So the client might be complaining about something's gone wrong on the file, but hasn't joined the dots that this is potentially negligence, or that actually amounts to a regulatory issue. So that has to be assessed holistically. And the way we deal with it with our firms is if there is an issue that looks potentially reportable, is having a conversation with the leadership team or whoever's our reporting angle to say, I think we've got an issue here. This looks reportable. Generally, insurers don't look unfavourably to notifications. They want to see firms notifying regularly when appropriate, because that shows that you've got a system of identifying issues early. What insurers get nervous about, particularly if you've got a profile of a firm which you would expect to have a lot of complaints and potentially some negligence, if there's zero notifications in one particular year, there's suspicion around that to say, well, hold on a minute, are they reporting up? Are they spotting when there's issues, particularly conveyancing firms? If I went into any size conveyancing firm and they told me they'd never had a complaint, I would be suspicious of that. And insurers would be too. Often notified issues to insurers generally don't come to anything. There's never actually a claim on the insurance, and insurers are aware of that as well. So the fact that you've got a number of notifications on your claims history, unless it's anything catastrophic or looks a bit meaty, that shouldn't negatively affect your next renewal, because it's expected that there would be some notifications in that year.
So it's a bit like some of the points that have been made about money laundering, isn't it? Where the fact that the legal community doesn't submit enough suspicious activity reports is suspicious, ironically, suspicious in itself.
I have a different view. I don't think it's that firms aren't reporting when there's something suspicious. I think that firms front load their CDD so much and are so focused on it that actually they wheedle out anything that could go on to be suspicious at the front end. Okay. So I think the barriers are so high and the nervousness is so high for a lot of firms that the reason it's low is because they've wheedled out anything that would have been suspicious early on.
Okay, that's interesting. I'd not thought about it in that way. And if the PI insurers are one elephant in the room, then perhaps the other one is the ombudsman themselves. They, as I say, they write a regular column for today's Conveyancer. And there are times when you sort of read it and think to yourself, oh, I'm not quite sure I would agree with that approach. And there are times when you think, no, actually, that makes a lot of sense. What's your experience of dealing with the ombudsman and their reaction to complaints?
So I've got around 4 years experience of dealing directly with claims which have gone to the ombudsman. So I've kind of seen their approach over those years. And having dealt with the ombudsman on a number of occasions has given me confidence. And this is why I speak so confidently about quickly signposting to the ombudsman, because my overwhelming experience is that they are very reasonable in their approach, and that as long as the firm has been reasonable in their attempts to try and resolve the complaint, I've found in the vast majority of cases, the legal ombudsman will say, actually, the firm's done the right thing there, and they'll waive their case fee. There are obviously the odd the odd anomalies where that's not the case, and you kind of take it on the chin, where we don't agree with what the Ombudsman have said. But overwhelmingly, I think that their approach tends to be reasonable. Where perhaps a bit more critical of the Ombudsman in more recent times is that they can take months to even start investigating an issue, and then when they do finally get to the point that they're asking the firm to provide evidence, the timescales they're expecting the firms to meet are very onerous. So you typically see 7 days to provide all this information on quite a complex case. So what we do there is we will push back on that and ask for more time. We've seen a number of cases recently, and perhaps an anomaly, where it's like preparing for a trial in terms of the evidence that they're asking for and the management time. In fact, there's one particular example where my team picked up the Ombudsman's response, and over 40 hours were put into providing the evidence to the Ombudsman, in which they came back and they wanted more stuff still. And then ultimately they said, actually, no, the firm's been reasonable. But if you think about that in terms of management time and a drain on resources, I think the balance is off. I think the balance is off on what firms are required to do to evidence what they've done. In, as I say, it's to that sort of standards of submissions for trial.
But I think the bottom line here, from what you've said, is actually having that evidence, having that audit trail. Even while you're running a case, you hope that it's not going to go to a complaint. But for all sorts of reasons, it's so important to ensure that you've got that audit trail and that backup should you ever need it.
Exactly, and that goes with so many things, in whether it's anti-money laundering, whether it's negligence, your insurers asking for information, or complaints. If you don't have that record keeping, you're in a very difficult position to defend yourself. And it may be that by the time the complaint comes out, or the negligence claim, or the anti-money laundering investigation comes around, the fear with conduct of that, the time has left. And all the firm's left with is their scrappy file, which may not support them. So really, that should be at the forefront of those that are responsible for ensuring good file management. Have that in mind. And yes, it's that the fee earner has a part to play there, but if they're gone, they're not there to answer to, and it's not going to help. Ultimately, it lands at the firm's feet.
We've run out of time, Kate. It's been brilliant to have you on the podcast. It's been a bit of a deep dive into complaints handling, and I have to say I'm very, very appreciative of your insights and what you've shared with us today. So thanks very, very much indeed for joining the podcast.
It's been a pleasure. Thanks, David.
The Today's Conveyancer podcast is available on your preferred podcast provider. It's also available on todaysconveyancer.co.uk. My thanks to Kate. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Conveyancer podcast, the leading source of information for residential property lawyers in England and Wales. Don't forget to subscribe and sign up to our free newsletter at todaysconveyancer.co.uk. You can also follow us on LinkedIn and Twitter.